We'll go ahead and call to order the Planning Commission meeting. Sorry, Julie, I'm a minute late for you. For tonight, December 3rd, 2019. First item on the agenda is our consent calendar discussion regarding the minutes from our previous meeting of November 20th. Any comments, conversations, discussions? Commissioner England?
Motion to approve.
Commissioner Thomas?
I'll second that.
We have a motion by Commissioner England, seconded by Commissioner Thomas. Any discussion to the motion? That sounds like a good motion. All those in favor? Aye. Any opposed? We're unanimous on that. And then our one and only public hearing, we'd like to welcome the public tonight to our meeting, is our text amendment conversation follow-up from our previous meeting. City of West Jordan is the applicant. We'll go ahead and turn the time over to you, Duncan. Dazzle us with the new changes.
All right, well, as you know, you have to have public hearings on land use ordinances. The council will, tomorrow night, actually have a work session on all of these same ordinances. And then next week, they'll have their public hearing on all of these same ordinances. So this is kind of the last part of the change of government process. There's not too many provisions that require changes purely for the purposes of the change of government. We talked about these at your last meeting a little bit. I did make some updates and changes based on the conversation last time. One item just right off the bat, I know that Commissioner Green brought up was the case cited Downs versus Thompson, whether that case was applicable here. Of course, in that case, that was dealing with whether a city can give appellate jurisdiction to district court. Of course, the general rule is no. This was pretty much a referendum type case, and it was dealing with a provision in state law of using public email for a political purpose. There was nothing in that election code section that gave jurisdiction to the district courts. So basically the ruling of the Supreme Court was if the state doesn't give jurisdiction, there is no jurisdiction and a city can't give it. Fortunately, in our case, in LUDMA, Land Use Development Management Act, section 10-9A-801, there's a general provision in there that district court may take, it's not technically an appeal, but it's judicial review of any final administrative decision by the city. In fact, it's any land use decision, administrative or legislative. So any final decision of the Planning Commission or of the City Council, even if it's say a zone change or something that's purely legislative, anything at all, any decision that's made by the city that's a final decision can go, someone can take it to district court for judicial review if they file within 30 days. So where that's a pretty comprehensive section that deals with everything in the Land Use Development Management Act, I think we're pretty safe with these 4 titles being all related to land use development. So, but I think it was good to check that just in case that we weren't running afoul of some recent change in Utah case law. So, so on that one, I think we're good. Trying to remember if you had any other main questions that from last time. In Title 12, remember that one was really basic. It was just a couple of changes of like terms of city manager to city administrator, and I think we changed the name of the department to Development Services Department instead of just Community Development Department. A couple things like that. Yeah, I guess in one instance at least it was city manager was changed to mayor. So there was somebody from a sign company that contacted me. We kept playing phone tag, missed each other, but I made it clear to her, at least in the voicemail, that we weren't making any substantive changes to Title 12, that it was just, like I say, changes to equivalent positions. So if there's no other change or no other questions on 12, we could go to 13. And
any questions about Chapter 12 or Title 12, Commissioner Green?
I had this thought this was like 2 days after the last meeting. I know we changed in the code where we referred to it as development services now as opposed to what it was.
Right.
What I was thinking, it hit me as I was doing something else. I'm wondering would it be better to just put put that in the definition section and refer to it as department throughout the section, and then if we decide to change the name next week?
That probably would have been a good idea, but where we're this far into
Okay.
it, maybe too late now.
Okay.
But you're right, that probably would have made sense, just put department and then put the name in the definition, and then if you change the name, we don't have to change it throughout, we can just change it in the definition. Yeah,
That'd be something for future.
yeah, that's a great idea. So Title 13, of course, is just it's the main zoning ordinance. Pretty much the same. I don't think you had any major issues on that title last time. Any concerns on Title 13?
Any questions, Title 13? No? All right, Title 14.
Okay. Title 14, subdivision regulations. That one, we had one of the other titles that we've been changing throughout this process is we've called the city clerk or clerk recorder. Now it's just city recorder, so we made some changes there. But not a lot of other changes because in our city, you, as a planning commission, together with city staff, have been handling all of those. Unlike other cities, the city council is really not involved in subdivisions. So, again, just the same kind of changes there, nothing out of the ordinary. Anything anybody else has on Title 14? Okay, so Title 15 was the big one that had, like I say, some substantive changes. One of the main changes that we talked about last time was on appeals, where the council can no longer be an appeal authority except for just when it comes to fees. And then we also talked about, if we go to the last page, and we can kind of work our way backwards, but the last page of Title 15, we focused a little bit last time on the appeal of conditional use permit revocations. So I added a citation, a reference in there, where it says the final action, and Larry's probably getting there, it's 15-5-6 now, used to be 15.5.8. But it says the final action of the Development Services Director revoking a conditional use permit made pursuant to Section 13-70-10 may be appealed to the Board of Adjustment. And if you go back to 13-70-10, that's the section that talks about revocation, where it says that you as a planning commission give your recommendation and then the director makes a decision. So I put a cross-reference back, if you notice in Title 13. I guess I should have went to that when we were in 13. But 13-70-10 says the final decision of the Development Services Director may be appealed as per Section 15-5-6. So I kind of made them cross-reference back and forth. So, yeah, and there it is right there, good. As people look and they can see if a conditional use permit is potentially being revoked, it's you as the planning commission doing most of the heavy lifting and work, making a recommendation, director making the final decision. If somebody appeals it, goes to the Board of Adjustment. The two are cross-referenced back and forth to each other. So does that look good to everybody now with that? Okay.
Question.
Yeah.
As I quickly ran through, it stayed right there, Larry, on that 13,
7E10 one, yeah.
where it says the planning commission shall, this is in that second or third line under 13-7E10, where it says the planning commission shall hold a hearing. Are we talking about this type of forum, or are we actually talking about a public hearing? It just, as I read that popped up, are we talking about public hearing, or it's really,
It's a little ambiguous. It doesn't clearly state public hearing or public meeting one way or the other.
Let me interject. When I worked in another community, we had this exact same process. And we would hold public hearings because oftentimes there would be people who had been affected by the conditional use that wanted to get on the record. So it's more of, and I don't know, I'm not an attorney, so I don't know if that's, it's not taking evidence, it's just taking their witness of what had occurred in a public hearing format. So.
as I was thinking, that's where I was leaning, is maybe we can just add the word public, hit the public there, and then we're required to send the notification, and then we're required to, and it would allow literally it allow a two-sided debate, that we're revoking it, the person that revoked it could speak, the people that didn't like it could speak. I think that makes it probably a better process, so that just hit me as we're sitting there, so hopefully, I think if we just added the word public there, I think we'd be better off.
Okay. So just at the beginning of that third line where it says hearing, just add the word public right before it. Yeah, that makes sense. I mean, pretty much everything else that you have on your agenda, unless it's a simpler or procedural item, you pretty much have a public hearing on it anyway, so. And certainly this is where typically the purposes of a public hearing is, one, to give information to the public, and two, to get information back from the public, and that's what you want here, I would assume, so.
For my part, I don't think we'd want an extra meeting just to do this. And
Right.
if we learned anything from the meeting 2 weeks ago, is that the public has information that we sometimes aren't aware of.
Right.
So I think that's important.
Okay. All right, so I'll add that word in. And then back to Title 15 then. Like I say, those other couple of last pages of Title 15, the Appeals Chapter 5. Again, now there's no appeals coming to you as a planning commission or to the council other than fees. Any appeal from either staff or the planning commission goes to the Board of Adjustment. So, so that process is kind of simplified. I think that's it, other than what we, oh, there was one other change, I think. No, I think that was it. Any other questions on appeals or anything else in Title 15?
Any other questions, guys? I think that's it for us.
Okay, that's all I had.
All right, we'll go ahead and open this up to the public if anybody has anything they'd like to say. All right, seeing none, we'll go ahead and close the public hearing. Bring this back to the planning commission for discussion, possible motion. Anybody else have anything else they want to add about this? All right. I'll go ahead and make the motion, since we're all sitting here wanting to do it anyway. Based on the information and findings set forth in the staff report, and upon the evidence and explanations received today, I move the planning commission forward a positive recommendation to the city council for this application, including the conversation, discussion, changes that we had just today as well. Commissioner Luthi.
I'll second that.
All right, we have a motion seconded by Commissioner Luthi. Any discussion to the motion? All those in favor? Aye. Any opposed? Awesome, we are unanimous. A couple of housekeeping things, guys. I talked with our mayor-elect. He indicated that they are voting on this, I think, tomorrow night on their calendar, but plan on January 29th and April 29th for joint sessions with the city council, at least for that January 29th. That is a Wednesday. All right, but we will be notified on that further. Do you have a comment about that?
On the January 29th, the reason that one's important is that's to address the PC form-based zone that we all said for like the Daybreak side, that we recommended approval. The council wanted to have a bigger discussion, so that's what that's.
Before they bring it
before they actually voted on the ordinance. So that's what that's for, is to have a discussion about that particular one. And I think there may be a second one that we're gonna slip in, but.
Yeah, Mayor Burton said that he'd come up with some more things, that he would want to talk about. So if you think of anything between now and the next couple of weeks, please let me know. And we'll make sure that we get it to him and to Scott to put together for that agenda. The other thing is on December 17th, in 2 weeks, I'm going to be, unavailable to attend, and I just found out that Commissioner Luthi will also be unavailable. Is anybody else going to be missing that meeting? Everybody else is going to be here? All right, we don't have a third person in charge. Kelvin, can you run the show for us? Is that okay?
Yeah.
It's your last meeting, so you get a chance to run the show.
And we're gonna miss Nicole's
Yeah,
last
so this is Nicole's last meeting, and next time will be Kelvin's next meeting. I think we're gonna be seeing you for a couple more years. So, all right, anything else, guys? All right, have a good Christmas and a Happy New Year. No, I'm gonna go listen to my wife's community choir perform. Only because we're leaving town on Thursday to go to Disneyland with the kids, so,
Oh, that is.
so,
And Nicole, you going somewhere fun?
It's my anniversary, so
Yeah.
I would be hung alive if I did not make that available.
I know we addressed the calendar a couple of meetings ago, but a thought came to me that, did we deal with the first one in August for the city's night out? I don't remember.
We talked about it.
I know did we, okay,
Addressed it.
okay. I couldn't
We
remember it.
did
It was-
address that.
I'm having one of those part-time, you know.
say that again.
I said, it seems that that only becomes concern when somebody's running for office that year because they want to be there, but there are no people running for office.
So we'll address it in we'll address it next December in case we have parties interested. All right, so somebody put that in the back of your brain for a year from now. All right, I'll go ahead and move that we adjourn.